We'll make a start. So good afternoon, welcome to our webinar. Thank you for joining us today. By way of introduction, Lauren and I will be your hosts today. We're both partners at Bass Green Solicitors. We both deal with employment law, both for individuals and for companies. We act in a wide range of employment matters, from day-to-day HR inquiries to assisting employees with grievances and disciplinaries. We assist in discrimination, whistleblower work, and represent our clients at the Employment Tribunal and beyond. Curzon Green are a multi-service firm in the City of London, High Wycombe and Marlow. We're listed in the Legal 500 as leading firm for 2022 for employment law. To make you aware, we are recording today's webinar and there will be a link to the slides and recording sent to all delegates. If you don't mind just keeping your microphone muted throughout, that would be great. There will be a section for questions and answers at the end, and please feel free to turn off your camera. You don't need to have it on, it's not a problem. So just to go through what we're going to cover today. First of all, we're going to look at some common contractual queries which we've seen arise in respect of employment contracts. Then I'll be providing you with an update on case law that we're starting to see come through the tribunal following COVID. And Lauren and I are going to be discussing the 5 crucial changes that we see on the employment law horizon for 2022. And then at the end, we're going to have a question and answer section. So if you have got any questions, please do submit them through the chat function. And Lauren and I will get to those at the end for you. We'll now pass over to Lauren to take a look at our first topic.
Okay, good afternoon, and thanks for the introduction, Jessica. So looking at employment contracts, we're going to start with the basics. So if we move on to the first slide, starting with the basics, we need to know what changes are needed to a contract to cover hybrid working. There are no particular formalities that have to be observed for entering into an employment contract. It may be expressed or implied, oral or in writing. Sometimes there will be a contract but will not contain all the terms agreed. For example, an employee may be working at home now with no written terms on this. However, it's clearly in the employee's interests to have terms in writing and in the employer's interest to obtain a signed agreement. Otherwise, it may be difficult to establish what exactly is being agreed or accepted between the parties, especially if there are any disputes. Where there are no terms in writing, we would look at the conduct of the parties over time. For example, if hybrid working has been happening for months, perhaps now, this may be implied contractually through custom and practice. While there are little the general contract has little to no formalities, Section 1 of the Employment Rights Act does require an employee to be given a written statement of certain specified particulars. The requirements of what have to be in this statement were updated in April 2020, so right in the midst of the early pandemic. The idea to give more information and provide more clarity to employees, although of course hybrid working was not really at the forefront then. A main change was that anyone commencing employment since April 2020 needed to be given a written statement of terms by day 1 of employment. And secondly, this day 1 right extends to workers and not just employees. In addition, from April 2020, employers have needed to provide information about the hours and days of the week that the worker works and how any hours vary. So for instance, shift workers would need to know when the rota goes out. That needs to be in the contract. Any paid leave, and this includes maternity, paternity, adoption. This now needs to be in the contract. Conditions of any probationary period, training entitlement, any training the employee must bear the costs of, for example, and any other benefits. There's been some debate about what this means in practice, given that the idea behind the change to the law is to give more information to employees and make it as useful as possible. It's recommended that this should include details about all remuneration, but not just pay. So vouchers, lunch, train ticket, season loan should all be set out in the contract. Although from 2020, many employment contracts have not been updated to reflect this, I mean, largely because of the pandemic and what's gone on, but they should be if they've not been already. An employee or worker may make a complaint to an employment tribunal if the employer has failed to provide a compliant Section 1 statement. They can only achieve between 2 to 4 weeks pay, so it's a nominal sum, and it can only be brought if another claim has been successful. With the thrust of plans to clearly give more clarity to workers and more information, more changes are due. Plans to introduce a new right for workers with variable hours to request a stable and predictable contract, whatever that means, is yet to be seen after 26 weeks service is coming into force, and possibly new rights and compensation for any short notice of cancellation of shifts. So we should expect to hear more in 2022 on these additional changes. Moving on to hybrid working. The proportion of workers in the UK who work entirely from home was relatively low until the pandemic. The numbers have obviously massively grown, and they continue to as employers reconsider their operating models generally, downsize offices and encourage hybrid working. Indeed, the government's flexible working plan, working task force has recommended that flexible working should be the default position for all workers post-pandemic. So employers entering into hybrid working arrangements now, or perhaps continuing them post-lockdown, need to address a range of legal and practical issues, and this really should be clarified in writing. So we need to think about updating the contract, obviously, considering any home working policies and updating those, any insurance arrangements which are required. Does the employee's home insurance policy cover it? Does the employer's insurance extend? Is any special equipment needed for continuing home working? But focusing on the employment contracts, we're going to look at a number of clauses. So just moving on to place of work and working pattern. So traditionally, the contract will say your place of work, and it's normally been your business location. The Section 1 statement requires this, but it also requires that if the employee is permitted to work at various locations, this needs to be stated. Therefore, remote working is a change to your place of work. The clause needs to be updated, and reference to home or home address should actually be now included in the contract. We have included just some brief drafting as an example on the slide. Where changes are made to any of the key particulars like this covered by the Section 1 statement, the employer needs to give this to the employee in what's known as a Section 4 statement. So a written change like this needs to be sent to the employee within 1 month. If this doesn't happen, again, the employee has a right to make a claim for nominal compensation of 2 to 4 weeks' pay. If the change has been instigated at the request of the employee, very likely the employee is going to be happy and accept. However, if a change to a contract, such as place of work, is being imposed by the employer, an employee may not be happy. For instance, it's the employer's decision to reduce its office size or change its operating model, then you really will need to consult with your employees and have them agree. Employers will need to consider when drafting and updating these contracts, is there a minimum expected attendance at the workplace? 2 to 3 days a week seems to be a popular approach. Are these set? Are they more flexible? This should really be in the contract. The employer will normally want to be able to require the employee to attend the workplace at other times, for instance, client meetings, team meetings, disciplinary matters or appraisals. Again, this should be dealt with in the contract ideally. When an employee is working from home, you also need to think about the boundaries of working time, and in particular, when an employee will be available. Will the employee be completely flexible in their hours or observe strict working time? Will there be a core period where they must be available? Can an employee be required to work outside those, for example, in the evenings? So commitments like childcare or dependent care will need to be considered and ideally catered for in updated terms. Working time regs, the Working Time Regulations 1998 lay down a maximum weekly working time of 48 hours. So has the worker opted out of that? If not, who is monitoring whether the worker is doing more or less than 48 hours a week? Employers should have mechanisms in place to ensure that records are kept about this and that staff comply with limits on working time and rest breaks. Failure to do so could result in a criminal offence being committed. And since no one is likely overseeing the working hours of those who are working at home and whether they take their breaks, the contract should be updated to say that those working from home are responsible for regulating their weekly working time and ensuring that they are taking rest breaks. Just moving on to pay and progression, employers should take care that salary and benefits provided to those at home is not less favourable to those in the office. If home workers are treated less favourably, they may have a claim under discrimination legislation. Any detrimental change to pay being forced upon an employee could also give rise to a breach of contract. Depending on the location of the employee's home, employers may consider a change is needed to any sort of location related salary band, for instance, London waiting. Employers should be very cautious about any detrimental change to a salary. As I've said, a failure to pay an agreed rate of salary firstly is a breach of contract, and it could give rise to a significant discrimination risk if employees are required to take pay cuts as a condition of a more permanent working from home or hybrid working arrangement. Consultation is needed, and employees may agree to a pay reduction in return for their arrangement, but either way, this should be agreed and put in writing and in the contract. Considering benefits, an employer is probably not expected to compensate for on-site facilities, gym or nursery benefits, for instance, provided that the home worker still has access to those, whether or not they use it. But if the worker will not be able to take advantage of the benefits, particularly if they're contractual benefits, the employer should consider whether they need to be compensated or an alternative arrangement should be given. Employers should not have a blanket policy which denies or hinders career progression to employees working from home. It's important to ensure office-based and home workers receive the same opportunities, for instance, with distributing work and projects, and employers should be aware not to inadvertently operate some sort of out of sight, out of mind approach to promotions and opportunities. Performance reviews should continue as normal, even when working remotely. Looking at expenses, there's no legal obligation to reimburse expenses for working from home unless there's something in your employment contract. Employers may contribute or they may not. Travel expenses, utility costs, telephone, broadband, heating, lighting, any increased insurance premiums. The ACAS Working From Home Guide does recommend that employers should be talking to their employees about this if there is extra costs to cover. The contract should really specify which expenses the employee can claim for working from home. And if no expenses can be covered or will be covered, this should be made clear in the contract to avoid any complaints or inferences. On confidentiality, employees have an implied duty to keep employers' business information confidential. But in practice, it's very difficult to police confidentiality when an employee is working at home, and even more so if an employee might be working in a remote place, like a cafe, for instance. So on this basis, the contract should carefully consider where staff are permitted to work and ensure that it's reflected in the terms. An express confidentiality clause should be in the contract, clearly defining what is confidential and highlighting how important it is when working remotely. To mitigate risks, the contract should cover things like maintaining private areas at home when taking confidential calls, keeping work data and personal data separate, requiring employees to position display screens so that only the employee can see the information, forbidding access by other household members, and breaches to this should be dealt with quite seriously. Disciplinary policies should also be updated to cover this. And finally, just looking at ending hybrid working. So what if things change? A contractual term ending the working arrangement should set out the circumstances in which it can be ended and any notice that needs to be given to end it. In practice, however, once the parties have embarked on a hybrid working arrangement, it's probably quite difficult to force an employee to revert to permanent workplace working, even if there is an express term in your contract. This is because there are discrimination risks, and to terminate an arrangement which has been working satisfactorily without good reason may be a breach of the implied term of trust and confidence. So the employee could claim they have been constructively dismissed. Therefore, any change or ending to home working should really only be implemented after proper, fair consultation and with reasonable notice to the employee. So I'll now pass to Jessica to look at COVID-19 developments.
Thank you for that, Lauren. And just a reminder, if you have got any questions, please do just pop them in the chat box and we'll get to those at the end for you. So I'm going to take a look at the recent developments that we're seeing in the tribunal following COVID-19. Just as a brief step back for you, so there's three main sources of employment law in England and Wales. So there's European law, but following the Brexit transition period, that's starting to have less effect on us. Although existing legislation from the EU is automatically changed to domestic law, so things such as working time regulations. Then we have legislation which is made by Parliament, so statutes, and then we have common law, so that's made by judges. The COVID-19 legislation that we saw introduced was made by Parliament. Disputes that happen between an employer and an employee generally are heard in the employment tribunal. However, in some limited cases, they can be heard in the civil court, but generally we're talking about the tribunal. Tribunal decisions, at first instance, aren't binding on other employment tribunals. So you could have exactly the same case going through Reading Employment Tribunal or Manchester Employment Tribunal, and the judges might reach a different decision. However, if that decision is then appealed to the Employment Appeal Tribunal or up to the Court of Appeal or Supreme Court, then it would be binding on the employment tribunals because they're the superior courts. So that is what gives us judge-made law. So just looking at what new law we got as a result of COVID. So there was obviously quite a lot introduced, but key to employment was furlough. So the coronavirus job retention scheme. That came to an end on the 30th of September 2021. In the 18 months that the scheme was in place, 11.7 million jobs were furloughed. That cost the government £70 billion. In terms of carryover annual leave, so the government announced that due to COVID, the working time regulations were relaxed. So that allowed workers who were not able to take all of their statutory annual leave entitlement because of COVID to carry it over onto the next 2 leave years. And then statutory sick pay was awarded from day one for those who were isolated due to COVID. In terms of the old laws that we saw become much more relevant, all employees and workers have a statutory right not to be subject to any detriment or dismissed for refusing to come into work in circumstances where they held a reasonable belief that they were in serious and imminent danger. We saw quite a lot of instances of people saying that this applied to attending work during the pandemic, where employers considered that the employee couldn't reasonably work from home. In terms of the new laws that came in, they were all brought in quite quickly. They were all reactionary. They weren't perfect, and things like furlough were accompanied by guidance which went through several changes, often without any notice whatsoever. So we were getting a lot of questions on what things really meant. How does X work in Y situation? We're all also trying to apply existing laws to a situation where those laws hadn't been drafted with the pandemic in mind. So now we're at the point where those laws and specific situations need to be tested by the courts and tribunals. So how do the judges interpret what these laws mean in each given situation to then give us this judge-made law that I was talking about. So I'm going to just have a brief look at case law. So as I say, these are all tribunal first instance decisions, so they won't necessarily be binding, but they will give us a good indication on how judges are going to start to approach these kind of issues. So the first case that I'll tell you about is the case of Mr. Rogers. Mr. Rogers worked at Leeds Laser Cutting. He'd worked there less than 2 years. So that's important because employees who have worked somewhere for less than 2 years don't have what we call ordinary unfair dismissal rights. In March 2022, his colleague has COVID symptoms. Mr. Rogers calls his manager and says he's staying away from the workplace until lockdown has eased. He said that the reason for this is that he's concerned about the risks that COVID poses to his vulnerable children who have sickle cell anemia. Mr. Rogers is subsequently dismissed. He brings a claim in the tribunal for automatic unfair dismissal under Section 100 of the Employment Rights Act. So that's the health and safety aspect that I was talking about earlier. That gives him the right to leave his workplace where he has a reasonable belief that being in it puts him in serious and imminent danger. Now, he doesn't need 2 years service to do this. Anyone can bring that claim. The tribunal considers his claim, but they say, no, we don't agree, you were fairly dismissed. The reason that they say that is because although Mr. Rogers was concerned about the risk of COVID, he'd actually breached the self-isolation guidance himself. He drove a friend to the hospital the day after he told his employer that he wasn't returning to work. The tribunal felt that this undermines his assertion that he was concerned about the risk of COVID to his children. They also said that his call to his manager didn't raise any concerns relating to workplace danger, and he couldn't demonstrate that there had been any such danger. He hadn't taken any steps to raise these concerns with his manager before he excused himself from the workplace. And crucially, the company had taken steps towards employee health and safety in view of the pandemic. So they'd carried out a risk assessment and they were following government guidance on social distancing and hand washing. They'd also provided masks to their employees in the form of PPE. So the tribunal decided that the serious and imminent danger needed to be judged on when the relevant acts took place. So what was known to people and when. They didn't accept that Mr. Rogers had established this required belief, and they also said that COVID couldn't automatically be treated as creating a circumstance of serious and imminent danger. Otherwise, every employee would be able to rely on this as a way to stay away from the workplace. It had the potential to give rise to a disproportionate number of claims. In terms of why this is important to you in your business, there's still obviously a lot of people working from home. So if you do intend to encourage people back on a more permanent basis, then we'd encourage you to look at your risk assessments, look at what you're doing and look at what you need to be doing. Also, if people refuse to return, look at why, and if that's a health and safety concern, then look at what you can do to allay those fears. The next case that I'll talk about is Mrs. X. So Mrs. X refuses to return to work in July 2020. She tries to argue that the reason for this is that it's on the basis of a philosophical belief. The philosophical belief that she's relying on is the belief to protect herself and others from catching COVID-19. The judge says no, that claim can't succeed, and this claim was actually dismissed at a preliminary hearing. It didn't even make it to a final hearing. The judge says that that's not a belief capable of protection under the Equality Act. Claims under the Equality Act are to prevent discrimination, and in terms of that, the judge didn't felt that reached the required standards. Again, why is it important to you? So consider that you might have people, for example, refusing to have the vaccine on the basis of philosophical belief. So it's important that before you introduce any sort of blanket policies that cover all employees, that you consider what potential claims you might have arise from things like discrimination, and consider those before you make any decisions. The next claim is a claim of Mr. Gibson. So Mr. Gibson worked at the Flying Leisure. He was a chef. He was sacked after he raised concerns about a lack of PPE and COVID precautions in the workplace. So Mr. Gibson had previously been on furlough in the first lockdown, and then he was brought back in. At this point, he raised these concerns because he had an elderly father who was shielding. Mr. Gibson was then sacked without any notice. He was told that the company was changing aspects of the business and they'd need a smaller team in the future. However, he brought this claim to the tribunal and the tribunal agreed with him. They said he was unfairly dismissed. They said that was because he'd either taken these steps to protect his father in the circumstance where he thought he was in serious and imminent danger. Alternatively, given what he'd told his employer about, he'd been told by his employer about needing a smaller team, they felt he was unfairly selected for redundancy on the basis of raising these complaints. So let's look at this back with Mr. Reynolds. In this case, Mr. Gibson raises these complaints to the employer. The employer doesn't do anything about it other than sacking him. The employer hasn't done their risk assessments. They also haven't followed these fair procedures. So what does this tell us for you? So in terms of what you should do going forward, it just shows us that procedure and paperwork really are key for defending these potential tribunal claims. Although the circumstances were slightly different, it's always important to act on any complaints that are raised, even if you don't think that they're necessarily fair. And the next one is about furlough. So in this case, the employee had been made redundant in July 2020 after the employer had seen a reduction for a demand for living care work following the pandemic. They weren't considered for furlough there. However, the tribunal said that a reasonable employer would have considered whether the use of furlough scheme could have avoided the need for redundancy, and therefore they felt that it was an unfair dismissal. This case has generated quite a lot of interest. However, employers who did implement redundancies despite furlough being available don't necessarily need to worry about this influx of claims. Most of those claims are going to be out of time now because there's quite a short limitation period for unfair dismissal claims, so it's 3 months less 1 day. And also, in our view, the most that you would actually need to do is consider whether furlough could have been used. You didn't necessarily have to use it. And we're actually seeing confirmation from the tribunals that there was no legal right to have been furloughed. However, again, what does this highlight for you? So it highlights the need to have a fair process when considering redundancies and also considering alternative redundancies. So what can we take from these cases? So as we begin to navigate the exit from the pandemic, in our view, it's a key time to review policies and procedures, not only limited to COVID-19. Remember that you need to risk assess your workplace, particularly you need to risk assess for pregnant women. If you are making any decisions, then make sure you record the rationale for those decisions. That rationale should be sensible and objective. If possible, try and consult with your employees before making these decisions so that you can tackle any issues before they arise. If somebody is raising concerns, then make sure you act on them. It doesn't mean to do necessarily what they want, but make sure you investigate them with them, even if you think they're perhaps not genuine. If somebody doesn't agree with what you've decided, then encourage them to use the grievance procedure, which you should then investigate. This all goes in your favour if you do have a later tribunal case. What you're doing is showing that you're a reasonable employer and that you're doing what you can. If you then do need to discipline someone or dismiss them, then remember that you need to act fairly. Record why you're making these decisions, record your processes, record your rationale. If you do get it wrong, as we've seen, there is a potential for claims. So there's potential ordinary unfair dismissal claims, which is available to anyone who has over 2 years service. That claim is limited to a basic award, which is the equivalent of statutory redundancy payment, and also a compensatory award, which is capped at 52 weeks pay. You might have the potential for automatic unfair dismissal claims for these health and safety sorts of claims. They don't have any statutory cap, so it could potentially be unlimited. And similarly, breach of the Equality Act claims, the compensation for discrimination is potentially unlimited. Lauren and I are now going to talk you through the 5 crucial changes that we expect to see for 2022 and beyond. So the first one I'm going to talk to you about is the extra bank holiday, which I'm sure everyone's very excited about. The Culture Secretary announced that the May Spring Bank holiday, which is usually at the end of May, is moving from the Monday to Thursday, the 2nd of June, and that we're getting a new bank holiday for 2022, which will be on Friday, the 3rd of June. So are your employees entitled to this? Well, it really depends on what your contract says. So by law, you don't have to offer your employees bank holidays, and certainly some industries you are required to work bank holidays. However, your employees have a statutory entitlement to 5.6 weeks holiday. For full-time employees, that works out to be 28 days. Most contracts we see expressed as 20 days plus the 8 bank holidays, or 28 days including bank holidays. However, you may decide to contractually give your employees more than that 28 days. So whether the employee gets that bank holiday or not as an extra is depends on what the contract says. So if your contract says 20 days plus holiday plus bank holidays, then they'll be entitled to this extra day because the number of bank holidays hasn't been specified here. If your contract says 28 days or 5.6 weeks, which includes bank holidays, then the employee again won't be entitled to the extra bank holiday because the total number of days has been specified. If your contract says 20 days holiday plus 8 days bank holiday, they wouldn't be entitled to it because again the number's been specified. We've seen a few that say 20 days plus the usual bank holidays in England and Wales, which is slightly less clear because this isn't a usual bank holiday. It doesn't happen every year. However, it is one that has been declared by the government. So I'd probably err on the side of caution if that's what your contract says. In terms of your options, if your employee isn't entitled to it and you want them to take it from their remaining allowance, then you can tell them that they have to take that Friday off by giving them twice as much notice as the amount of days that you want them to take. So it's 1 day here, so you need to give them at least 2 days notice, although practically you're going to want to do it much more in advance than that. However, it's worth thinking about employee relations here. What's the cost to your company compared to the benefit of having your employees quite happy that you've given them this extra day? It's also important to remember part-time workers, so you need to treat them fairly. If you do give your full-time workers an extra day, then consider giving part-time workers a pro rata entitlement to that bank holiday to address that.
Thanks. And now looking at the national minimum wage and other pay increases. So national living wage for workers aged 23 and over is going to rise from £8.91 to £9.50. So that's a 6.6% increase. The national minimum wage rates for young workers will also rise, and you can see the various age groups on the slide. Statutory sick pay will increase to £99.35 per week. Statutory maternity, paternity, adoption and shared parental pay and maternity allowance, they all go up to £156.66 per week. We also, in relation to pay, but not expected this year, is we've had news about tips regulations. So the government just announced new law requiring employers to pass all tips to workers. A tweet on the 1st of February stated, "Tips earned by workers should go to the workers they were intended for." We will bring forward legislation requiring employers to pass all tips to workers as soon as parliamentary time allows. So we're not quite sure when that's going to come through. It may be this year, it may not. What we do know is that the government is going to give employers enough time to adjust their business practices. So they think that the legislation might come in and then they might have at least 1 year to adjust to the new tipping process. And finally, it's going to include a right for workers to make a request for tipping records to help them make any claim, to bring forward claims to the tribunal if they think something unfair has gone on relating to their tips. So that's all quite good news.
Thank you. So the next one is the Health and Social Care Levy. So this is going to impact employers and business owners as well as employees and the self-employed. So in the short term, what's going to happen is national insurance will increase by 1.25% from April 2022. At the same time, tax rates on dividends will also increase by 1.25%. Then from April 2023 onwards, the Health and Social Care Levy is going to become a separate tax on earned income, with national insurance rates returning to their current level. It's important to note that at this point, workers over the state pension age who currently don't pay national insurance will still have to pay that 1.25% levy. It applies to employers as well as employees, so businesses are going to need to budget for these additional costs from April 2022 onwards. So for example, if you've got somebody on a £50,000 salary, it's going to mean a £505 increase in employee national insurance contributions and a £514 increase in employer national insurance contributions.
Thanks. And number 4, so it's expected in 2022, not guaranteed, could be later, but it's a new legal duty to prevent sexual harassment. So according to a Rights of Women survey from 2021, January, 45% of women surveyed in England and Wales had been sexually harassed on online work platforms since the start of the pandemic in March 2020. So last year, on 21st of July, the government published a response to a consultation on workplace sexual harassment that had been launched in 2019. The response confirms that the government will introduce a new proactive duty on employers to prevent sexual harassment in the workplace, and new protection from third-party harassers too, so that's clients, customers, suppliers, and so on. It's also considering whether to extend the time limit for bringing discrimination and harassment claims from 3 months to 6 months. This is because the consultation found that the impact of trauma arising from sexual harassment was common, as was the potential barrier to justice that the current 3 months time limit could create, especially in other types of cases such as pregnancy and maternity discrimination. Yet to be confirmed when this new duty will take effect, as I said, or when the time extensions might apply, but draft legislation is anticipated and provision could be made for this in the employment bill. So the long-awaited employment bill didn't progress much in 2021 for obvious COVID-related reasons, but it might finally make its way through Parliament now in 2022. It promises another of other reforms to employment law, including in relation to flexible working rights from day one for all workers, rather than needing 26-week service to request this. I've looked, and the next stage of the bill is a second reading, which is scheduled to take place on Friday, the 18th of March. So thankfully it does seem to be progressing. And further, a new statutory code of practice is expected to be published by the Equality and Human Rights Commission, and that would support employers in understanding their duty regarding sexual harassment and some guidance. So it would build on the guidance that's already out there, and obviously with it all being the upshot that there's a step to change in how employers are required to manage the risk of harassment, especially in a post Me Too world.
Great. And then the final point that we wanted to mention, which should also be coming in the employment bill, is neonatal pay and neonatal leave. So following consultations, the government has pledged £15 million in the budget in March 2020 to introduce this new neonatal care and neonatal pay. The date that they're currently working towards is April 2023. However, the law isn't in place yet. We're still waiting for it to come in. However, from the budget, the intention is that parents whose babies are in neonatal care for over a week will be entitled to statutory paid leave for every further week their baby is on the unit, up to a maximum of 12 weeks. It's going to be available to all parents of babies in neonatal care, whether they're born premature or whether they're born at full term. That leave is going to be paid at a rate of around £160 per week, but again, we're waiting on the figures. And it's going to come in addition to other parental leave, so leave such as maternity and paternity leave.
Great, thank you. So a couple of final points. This is an update based on the information available today, guidance and law as at 9th of February. So it's for information only and shouldn't be considered formal legal advice. Always consult the latest government guidance or seek up-to-date legal advice. We'll now open it up for some questions. And I think a few have come through already, so we can start with those. But if you do have any, please put them into the chat box and share them with us. Equally, you can contact us after. We've got some contact details on the screen, so you can feel free to drop Jessica and I an email.
Great. So the first question we've got, if I have not given an employee contract, can I get rid of them without notice? So you can't. So even if your contract doesn't have a notice period in it, employees are entitled to minimum statutory notice after they've worked with you for a week. So that is 1 week for every year that they're there for up to 12 weeks. If you don't do that, then you face a potential wrongful dismissal claim. The exception to that is if they've committed gross misconduct. So you could dismiss them without notice there. But that's quite a high bar to reach. It involves basically them doing something that goes to the heart of the employment contract. That means that, you know, you can't possibly employ them, but you need to have a fair process to be able to rely on that. If you don't, then if somebody's been there over 2 years, they have that potential unfair dismissal claim. You don't need 2 years for wrongful dismissal. You can bring that, otherwise it's breach of contract. And I guess the risk is of not having a contract is that you have that potential piggyback claim. So that Lauren mentioned earlier, that if they can bring a successful other claim in the tribunal, then they could claim up to 4 weeks extra pay by virtue of not being given this Section 1 statement.
Yeah, absolutely. We've also had a question about refusing to come back to the office now. Not sure on what circumstances, but there's a couple. So either this person maybe is wanting to work remotely for non-COVID related reasons and is looking at home working, or it could be because COVID is still around. It could be health and safety. So I think the first one, looking at if it's just wanting to continue working from home, I think you need to consider the reasons why and engage in consultation. Can the role be performed at home or not? If it's been working reasonably well for the last whatever period of time, you really need to consider why that needs to be brought to an end now, and why the person needs to be in the office, and consider business needs. So a couple of meetings would be needed, discussions around what can and cannot work, considering business needs and the employees' needs. Consider, is there childcare dependent needs? Is there a disability related angle? Is there some sort of health reason for working at home? These all are things that would flag as discrimination risks if you don't deal with them properly. So you really need to get to the bottom of the reason why, and then looking at COVID. So if it's sort of a health and safety reason or a fear, you need to work out, is there a health condition, is there a disability complaint that you're at risk of, and also just generally, is there health and safety concerns. So all employers and have to follow health and safety at work requirements, and that requires risk assessments and making sure that you're following COVID requirements and so on. So I'd consider both, and getting to the root of the reason why, and then making sure you properly consult and have considered all options before forcing someone, because the upshot may be that you're going to dismiss this person if they don't come back in, and that could be very risky in the circumstances.
Yeah, absolutely. Agreed. Question. So should employers be expected to cover the cost of supporting employees' well-being when working from home? Does it depend on the size of the organisation? I mean, that's quite an interesting one. I don't necessarily think that they will be expected to cover that cost. However, if you've got people working in the office that are being offered something, then that certainly should be extended to people working from home. You still have obligations under the working time regulations and things like that, to ensure that they're not working beyond that 48-hour working week if they haven't opted out, and they still have the right to take rest breaks. So while not necessarily, I think legally you've got an obligation to support those costs, I certainly think that there's benefits of doing so, and making sure that you don't end up with that out of sight, out of mind policy that we've discussed. And in terms of sort of good employee management, I suspect it's something that you could certainly look to introduce either as a formal policy. So whether you bring in some sort of benefit, or even just ensure you have a check-in with your employees on a regular basis. Doesn't necessarily have to come at an extra cost, but perhaps change the way you're doing your reviews, perhaps meet with them slightly more often. We've heard of people doing things like lunchtime coffee breaks so that people can have a conversation, virtual events, things like that. What about you, Lauren? Do you think there's anything?
No, I agree. I think treating, so if there's a wellbeing initiatives in the workplace, you have to make sure that those working at home can benefit too. And I think what you've just said about holding checkups, and that might be all that's needed, checking in, opening communication, really open, and some sort of wellbeing policy and training is always going to be good. Yeah,
absolutely. And I suppose from a discrimination perspective, if you're alive to the fact that there might be mental health conditions that can fall under potential disability, then having those policies in place to set out how you kind of deal and support people is going to help you if you did end up in a tribunal situation. Obviously you need to have the policies, but you need to actually follow them as well. So that's the key thing.
Great. We've probably got time for one more very briefly, which is just if someone goes to work for me in another country. Good question. May have happened, may have already happened, could be short term, long term. There's quite a lot of risks because the person in the other country might well get local employment rights, so the rights in the country that they're working in. So for instance, if in the UK there's ways that people can be dismissed fairly, and that may not apply in the country that they're working in. Think about local things such as local bank holidays, local other things you must account for, changes to hours, and also tax. So there's also a tax consideration and pay. So there's quite a lot to think about.
Yeah, absolutely. And even things like GDPR and reviewing your internal policies, check what's on there, check that if you say you've got life insurance or something like that, check if the employee can still benefit from that if they're working in another country. So just quite practical things. It's definitely one you'd want to take advice on.
Yeah, certainly. So take advice, and you might even need advice in the host country as well as here, and considering the links to the host country and the country that the business is based in. So pretty complex one, but lots of there is obviously lots of case law and considerations on it. So take advice.
Yeah. Great.
Brilliant.
I think that's probably all we've got time for today, but thank you ever so much for joining us. As I say, this will be circulated to all delegates, and if you have got any questions, then please do just contact Lauren and I. But enjoy the rest of your day. Thank you.
Thanks a lot.